I was not here. Okay. Yes. Where were we? I just read the in conclusion, therefore, the discharge of the petitioner therefore cannot be said to be absolute, as respondent NIA has reserved its right to proceed against him, should the need arise on further investigation. Further, there was prima facie grounds for detention of the petitioner, and the arrest cannot be said to be wrongful or the presence of any element of malicious prosecution in the conduct of respondents. This court, therefore, for the reasons stated above, in consideration of the entire case in its totality, especially the facts circumstances surrounding the arrest of the petitioner, finds no case has been made out for grant of any compensation under public law remedy under Article 2 of the Constitution of India. Writ petition according stands dismissed.
Any mention?
Please, Your Lordship, I'd like to mention item number 24.
Number?
24.
24.
I pray for 2 weeks' time, Your Lordship.
I'm appearing for the state respondents, Your Lordship, in this matter.
You're with Mr. Chakravarti?
Yes, Your.
Why you want to take time? 2 weeks?
Yes, Your Lord.
Yes.
Highly obliged.
In respect of item number 57.
Yes, Mr. Pathak.
Item 57 was to be listed with an analogous matter, WPC 31 of 23, that has not come up today, my lord. So can this be taken up together on some other day?
Is that correct, Mr. Mumtaz?
Your Lordship, actually, yes, there's also another similar pending matter also, Your Lordship.
What is that number?
This is WPC 31 of 2000.
Oh, 31, yes. Mr. B. Pathak submits that the an item that was 37 submits that the matters had been directed to be listed together with WPC number
31 of 2023.
31 2023. Stop. As such, he prays that the matter be listed together on when? After?
2 weeks.
After 2 weeks. After 2 weeks, yes. Well, this matter along with WC number 31 2023 on so and so. Right.
Lordship, I'd like to mention item number 26 of the hearing list. 26, Lordship.
You're there?
Lordship, I've taken consent of the, yes. 26.
What's the matter about? Teacher case?
Teacher, Lordship, termination.
2 weeks, yes.
Lordship, I beg to mention item number 23 also, Lordship. 23, Lordship.
Teacher's case?
Yes. This 3 weeks, Lordship.
Why?
So I have little difficulty to do.
3 weeks, yes. 2020 matter. Yes,
please, Your Lordship. Lordship, I beg to mention item number 34.
34?
34, yes. I pray for 3 weeks' time, Your Lordship. Conducting counsel is unavailable, Your Lordship, due to some unavoidable circumstances.
You for the petitioner?
For the petitioner, my lord. I will claim for the petitioner.
Right, Mr. Setigi, 3 weeks due to the unavailability of the counsel for the respondent number
2 and 3, Your Lordship.
2 and 3. Okay, yes.
Lordship.
Yes, that's it.
Your Lordship, I beg to mention item number 35.
Cornelius Sani.
Yes, Your Lordship.
Why? Where's Mr. Dominic Varjadi?
My senior is not keeping well, Your Lordship.
Yes, 2 weeks as the conducting counsel said to be in this post is. Your father's side, Mr. Pasantes?
Yes, Your no objections, Lord.
Please, Your Lordship, I beg to mention item number 36 to file our affidavit.
36?
Yes, Your Lordship, I pray for 2 weeks.
Who's for the petitioner? Who's the petitioner? He's taken your consent? No.
Lordship, they're supposed to file the counter affidavit.
Who's supposed to counter affidavit?
The private respondent.
Who's private respondent?
I pray for 2 weeks.
Respondent number 4.
Don't mention it just like that, then you get supposed. How can it file counter and it's come in the hearing stage?
Lordship, what happened in this case? There was an ex parte order against the respondent 4. Now they have filed an application.
Who's respondent number 4?
Me, Your Lordship.
The application was allowed and you're supposed to file the affidavit now.
Okay. In this case, now, your name?
F. Lang Benang. F. Lang Benang.
No. Yes, MSF Blanc, General Counsel for the respondent number 4. Please allowed further. How much time?
2 weeks time.
2 weeks time to file affidavit. Mr. Ahmed in the threatened with prayers allowed. List this matter after 2 weeks on so on an order column. Yes.
Please, Your Lordship, I beg to mention item number 32.
What's the matter about?
Cancellation of Pata, Your Lordship.
Objection, my lord, for 1 and 2.
Yes?
I don't have any objection.
No urgency. 3 weeks, yes.
Much obliged.
Yes.
Similar prayer for item number 27, Your Lordship.
Where's Mr. Thaba?
He's not keeping well, Your
Was
Lordship.
it fixed today for last time? What orders were passed? What happened last occasion? What happened last occasion?
On the last occasion, there was a dispute filed by Mr. Thaba.
Yes.
Bringing force to the school, madam.
What, misplay with the jump? This is matter on 13th. Yes, together with the connected miss case. 27.
Lordship, I'd like to mention item number 30. I need some more time to prepare.
30?
Yes.
What's there to prepare? What do you have to say in that?
No objection, Lordship.
What? No. What? That you what? No. If your submission, what remains as a matter?
Lordship, it was in mediation, Lordship, the matter was sent for mediation.
Yes.
So the matter could not be settled, Lordship.
Yes.
And therefore, it is again before your Lordship.
Let's talk of 2 weeks, as it's reported that was it recorded earlier time mediation has failed.
Yes, sir.
Yes, Mr. Yubin. You because you're not present. This is after 2 weeks. After,
This matter was referred. Yes.
yes, it's all right. Yes. That's the availability of Mr. Yubin, Army Council. Yes. Yes.
Lordship, I beg to mention item number 33, Lordship.
You exhausted the list also.
30.
No objection, Your Lordship.
Don't do one case also in a day. 2 weeks.
Yes, Your Lordship. Should beg to mention item 28.
What remains?
Well, this Nokmarship dispute, my lord. Nokmarship.
Yes?
Dispute of Nokmarship.
Are you ready with the matter?
Yes, I am ready, my lord.
Are you ready with the matter?
It's 1 week, Lordship. Not
1 week. A request to respond to this.
Most of this.
Yes. Call out the matter.
Supplementary list. Item number 2.
My pleasure, Lordship. Well, the petitioner has been superseded in the matter of promotion to the post of Subedar Clerk on account of uncommunicated SER. Uncommunicated SER, my lord. This was never communicated. And his MSCP also denied on this ground also that he is having below benchmark grading. That was never communicated to him.
Are you still in service?
My lord, he is still in service. He is still in service. I am challenging the annexure 6 and 9, my lord. That requisite requisite qualitative not
Where
qualified.
6 and 9?
See, annexure 6 and 9, my lord. Page 56. Page 56 and 65, your lordship. 56 last para, your lordship. In the light of the new benchmark system, 7th, the individual does not meet the requisite You are for
So you want to take advantage of the judgment bench order? See the uncommunicated, that means that, yes.
Yes,
You
your
want to
lordship.
file
also.
affidavit or no?
No, today first day.
Your Lordship, it's been listed this morning.
Yes?
Today it is first day.
Do you want to file affidavit or
Your
no?
Lordship, we will be, but however, Your Lordship, if this matter may be called up after some time again, Your Lordship.
Okay, call sometime. Otherwise, we'll dispose it of. Yes.
3. Item number 3.
Yes, Mr. Jha.
My lord, it's also denial of promotion, my lord.
Uncommunicated ECR?
No, my lord. No.
Then?
It's denial of promotion on the ground that he is involved in court of inquiry, my lord. So, on discipline, page 37, my lord. Page 37, my lord.
37?
37, my lord.
Yes.
My lord. The last, not considered for promotion due to involved.
Where are you reading from?
Page 37, only bottom line in that column, my lord.
Or also due to involved disciplinary case?
My lord. Court of inquiry, my lord. My lord, disciplinary case starts when the hearing, my lord, page 75, if I take you, my lord, to page 75.
Yes.
My lord, it's Army Order 24 by 94, my lord. The first line, my lord. Disciplinary process under the military law commences after the Army Rule 22, that is the hearing of charge, is followed, my lord. Then the disciplinary case starts, my lord. Here it is a case where still the court of inquiry. Court of inquiry is a fact-finding, my lord is well aware of. So I am challenging that.
Or whatever it is, Mr. Jha, some proceedings been drawn up against you.
My lord, here the proceeding
has not started as per your submission.
As per
the district process is a different thing, court of inquiry is a different thing.
Different, my lord.
So because they've said district proceeding, different case here, they have not said district proceeding. They said
disciplinary case
due to involve disciplinary case.
Case, my lord.
Case means what?
Case means, my lord, it's here it is also a case, my lord, where the preliminary inquiry was already over, my lord. And even the second court of inquiry they have conveyed, my lord. Please, my lord, if I take you, my lord, page 33, my lord.
Yes.
My lord. That was the Annex 5, my lord.
Yes.
This is the convening order, my lord.
No, see, so-and-so, Umroy so-and-so to be a unit to be dealt with. See, the thing is that they don't say that disciplinary proceeding. They say that in connection with disciplinary case.
My lord, let them file an affidavit. As of now, my lord, I am not seeking any stay of this. A notice has to be. My lord, here it is clearly specs that the court of inquiry, the bottom line, my lord, the court of inquiry should be completed on 5th June 2022. But still.
Okay.
Your Lordship, I pray if this matter may be called up after some time, Your Lordship, as learned DSG is still on legs.
But then why didn't you say that in the beginning? At least you owe your Mr. Jha that courtesy, yes.
Item number 4.
Wait, please, Your Lordship. Lordship, here, my lord, we are aggrieved by an order passed by the Meghalaya Lokayukta, where, my lord, my complaint petition filed before the Meghalaya Lokayukta has been rejected as being barred by limitation. What happened, my lord, was that a complaint, my lord, was filed by the MLA of Mendipathar, my lord, in the year 2014 before the Deputy Commissioner with regards to, my lord, the release of funds by the BDO and the ex-MLA. The case was, my lord, that the ex-MLA
filed in 2014.
Lordship, yes.
9 years ago.
Yes, my lord.
Then?
2014. The scheme was of 2013. We filed the complaint somewhere in June 2014, my lord, before the Deputy Commissioner, because the Deputy Commissioner is the nodal agency for that that scheme, my lord. Thereafter, my lord, the complaint was not disposed of, or there was no action forthcoming. Hence, my lord, we approached this honourable court by way of a writ petition with the direction, my lord.
Which year was that?
That was, my lord, filed in 2016, my lord.
Okay.
Lordship, by an order of 7th of September 2016.
Where's that?
Lordship will have it at page 26, my lord. Page 26, my lord, is WPC 245 of 2016. Lordship will have the date of the order on the next page, my lord, on the top of the next page. By this order, my lord, the operative part is at page 31, paragraph 4, lordship. Essentially, my lord, the direction was given to the Deputy Commissioner to dispose my representation of complaint, my lord, within a period of 15 days. And the matter was, my lord, disposed of. Thereafter, lordship, we have duly communicated. However, my lord, the Deputy Commissioner did not dispose of my representation. Hence, again, we approached, my lord, the Honourable Court by way of writ petition 400, lordship, which lordship will find at page 32.
Yes.
But during the pendency of this matter, my lord, by way of an interim order, this Honourable Court was pleased to direct the Deputy Commissioner to hold an inquiry and give opportunity to the petitioner and submit a report before this Honourable Court. In that report, my lord, what happened was, although the direction was given to hear me, I was never called, and because of violation of national justice, my lord, that inquiry report was challenged by me in that proceeding. However, my lord, 400, lordship. However, lordship, the issue was that since I have not made any challenge to the inquiry report in my original writ petition as it stood, a liberty was sought, my lord, to file it afresh, and the matter was, my lord, disposed of, and contempt also was, my lord, eventually disposed of.
Okay.
Thereafter, lordship, again, after challenging the inquiry report, we approached this Honourable Court by way of, lordship, the writ petition 144 of 22.
Yes.
And there, my lord, what eventually transpired was that this was a case of, my lord, disputed questions and an issue of corruption which has to be looked into. Hence, my lord, the petition was withdrawn with liberty to seek alternative remedy, and that was allowed, lordship, in November 2022. Thereafter, my lord, after my lord compiling all the documents and everything, we have approached the Meghalaya Lokayukta, my lord, with a complaint,
yes,
along with a prayer to condone the delay, as we were before this Honourable Court right from 2016 onwards, lordship. So as such, there was no latches on our part. But however, my lord, by order of 13th of June 2023 at page 34, which is the impugned order,
yes,
lordship, in view of section 53, my lord, which is quoted in the order itself, there is a time limitation of 7 years from the date of the offence mentioned in the complaint. My lord, I understand that the complaint was filed in 2014. So, as such, they have said that it is barred. But my humble submission is, my lord, that it is not a case that we were not
diligent.
Not diligent, my lord. We were not sleeping over our rights, and we were always, my lord, proactively pursuing the matter. Eventually, with the liberty to, my lord, approach the alternative forum. So I am praying, my lord, under 226, lordship has the power, my lord, to condone the delay and to my lord, direct the Lokayukta to decide my complaint on merit.
Yes, Mr. General. Is shall.
Lordship.
Shall is the word used.
Shall.
Yes.
That is, it imposes a duty.
Yes, shall. It says shall, right?
A duty on the
shall
locator.
inquire, investigate into any complaints after expired 7 years. Yes, what do you have to say?
Yes, my lord. Just two small things. Lordship, firstly is my friend's submission today that they had asked for condonation. That appears to be an afterthought because number one, nothing is reflected in the order. Number two, there is no pleading to that effect in the writ petition. And number three, the complaint petition which he has filed is also not part of the record. So in any event, leaving that aside for a moment, Lordship will kindly appreciate what petitioner seeks or what petitioner is requesting this Honourable Court to do. Section 53, my lord, of the Act, it is a very clear provision, my lord, and there is no condonation provided in the Act itself. So therefore, through this writ petition, the petitioner wants this honourable court to read a condonation provision into the Act. Now, boundaries of writ jurisdiction are vast, no doubt, but are they vast enough to enable this honourable?
Where's the complaint petition?
Complete petition, my lord, it's rather bulky. I can
Why
place it
you
by
have not
way of-
annexed it?
My lord, it's quite voluminous because all the pictures, and I can place it by way
Pictures?
of affidavit, my lord. Tomorrow itself I can place it by affidavit, my lord. I have made the statement because we had filed the complaint along with the condonation saying that, my lord, the matter was pending before this honorable court. And
Whatever it is, at least if you want to go on materials to record, it should form part of your,
complete
hearings and-
petition, my lord, I can file it by way of additional.
Also to see whether you made what kind of prayer you made there.
The prayer was, my lord, to
Whether did you ask for condemnation?
yes, my lord. In fact, I have made a statement.
Have you
in
quoted section 53 of the Lokayukta Act?
Yes, yes,
That
Lordship.
since it stipulates that
Yes,
of
Lordship.
7 years.
We have specifically stated that provision. We have admitted that it
You
is
stated that in the petition.
Yes, my lord. At paragraph 12, Lordship will see, my lord, page 18. Page 17 it starts, Lordship. The relevant part is at page 18.
He's sitting MLA.
Lordship, yes, my lord.
So he wants to settle old scores.
No, what happened, my lord, was what the original issue which was there was that the concerned BDO, my lord.
Forget the BDO, he wants to settle old scores.
No, not old scores. We are only
When he was out
concerned
of
with
power, the BDO was mean to him or his people, and so he would settle old scores through using statutory
No, Lordship,
measures.
we are not against the ex-MLA or anyone, my lord. I am only against the release of the funds which
Yes.
was...
But Mr. S. Deb, constantly issue notice, Mr. S. Jindal, you put an affidavit is present and on behalf of
For both respondents.
both the respondents, no further notice called for. This is a matter of the 3 weeks for affidavit stop. Mr. S. Deb to produce a copy of the complaint filed for Lokayukta on the next date.
Main list, item number 1.
Because if there is opposite party, they are yet to file the affidavit. There is a order.
2 weeks time.
Where's Mr. Day?
On legs.
Further 2 weeks time granted respondents to file affidavit. Is thereafter also.
Item number 2.
May I please? Well, I have the friend has filed the affidavit in opposition also.
To the condition application.
Yes.
Where's
Condonation. The main thing here, my lord, the petition is revision petition is under Article 227. Actually, there is no limitation for petition under 227, except that there should not be inordinate delay. Now, under the Limitation Act, my lord, this petition will fall under Part 2, other applications, Article 137. Any other application for which no period of limitation is provided elsewhere in this division, limitation is 3 years. So I'm well within the limitation of 3 years. 3 years means 1095 days.
If you say that it's under 227, why do you file an application under section 5?
Pardon?
If you say that it's a 227, so limitation act will not apply, why do you file an application under section 5 then?
Because earlier I had thought that Order 9, Rule 9 was applicable. Then later realized that after filing the condonation application, realized I got the ruling also of our High Court. Then realized that Order 9 Rule 9 is not applicable actually, because the case was not fixed for hearing on the date when the case was dismissed. and that dismissal order was against a dead person. So that order is non-est ab initio. I had furnished the ruling of our High Court also, I think, on an earlier date. One more is here. This High Court says, in short, dismissal of the suit for non-appearance of plaintiff on the day not fixed for hearing. Application or restoration of suit filed after 30 days of the order of dismissal. Trial court declining to condone the delay and consequently dismissing the application for restoration of suit. Held, Order 9, Rule 9 would have no application in such a circumstance. The application for restoration of such a suit would fall under Section 151 of the Code, and the period of limitation would be 3 years. That is under this judgment. Here it says 151, which is the inherent power of every civil court. Aim of that section is to do justice. The 227 is the power of the High Court. Aim here is also to do justice.
Let's see application. You are appearing for 1 and 3. What about the other respondents?
Not only 3 respondents, but 1, 3, and 6. The other 3
others have not appeared, and case had gone ex parte against them.
You are appearing for 1, 3, and 6.
There's no order of ex parte.
Referring to learned friend's affidavit, para 10.
Just one clarification, my lord. My lord, order dated 21st of October 2022.
Yes.
Yeah, my lord, Mr. Bora had sought for time to obtain the status of service.
He has filed it.
You have filed it.
Yes, he filed it.
But there's no order after that.
Where is that order dated?
The 21st of October 2022.
21st of October.
Yes, my lord. Order dated 2nd of December only says that affidavit has been filed, my lord.
Yes. So that we can take it, that we can correct it.
My lord.
Again, coming to the counter affidavit of Planet Trail, 1 and 6 has not authorized. The authorization is not seen in the affidavit. And mostly, Planet Friend is talking about application of Order 9, Rule 9, which is not applicable in this case because the dismissal order was on a date when the case was not fixed for hearing. Then there is a mistake.
It was fixed for what on that day?
12/7/2017, I think. The delay is 1030 days. Under para 10 of his affidavit, he has written that petitioner was alive when the application was filed. That is wrong date taken by him. It is not 20 March 2017. It is 20 March 2018 when the application was filed. and plaintiff had died on 26/7/2017.
No, only one question is there, Mr. Bora. This matter was dismissed by the trial court, correct?
Yes.
Why you have come here?
We had filed actually several cases.
No, why have you come here to the under 227 to the High Court?
Because there I have no locus standi because the case is not yet restored. I have not been.
Doesn't matter. Why do you have you come here? You have a forum of appeal provision under this 53 rules.
The proceeding which I had taken under Order 9, Rule 9 and all, that has been dismissed because that is not applicable.
No, your argument is nowhere. Your whatever matter, can it be A, B, C, D, or any type, any color, any flavor has been dismissed by trial court.
Actually, that
where's the remedy, first remedy?
What he is talking about, 23/2018, I had filed one application.
No. We're talking about the last, where's the last impugned order, correct? If you bring it here 227. You know what are the limits of 227?
I had to wait for the final order of that petition. That was disposed only in last year only. (15/7/2022). Thereafter, I had come here because that proceeding had not finished. The fate of the dismissal order was not decided. By this order, the lower court had decided that the dismissal is right.
On what grounds was your matter dismissed by the trial court? Let's see the operative part of the order. We go first from your impugned order.
Hence, in view of the last paragraph, second last paragraph,
yes,
observations. Hence, the observations are above. There also that Order 9, Rule 9 would have no application if etc.
Why did you file under Order 9, Rule 9?
Pardon?
Was it filed under Order 9, Rule 9?
Initially, it was filed Order 929.
Then?
That was allowed by the Subordinate District Council Court. Parties went on appeal. The appellate court reversed it. Dismissed that.
So come to the operative part. On what ground was it dismissed? Let's see. What are you reading just now? Just read it again.
In view of the above observation, as this instant application is time barred,
yes,
and no application has been filed by the counsel for the petitioner for condonation of delay, the prayer of the counsel for the petitioner for substitution and restoration is accordingly rejected.
Naturally.
There also I had made my submission was
see, Mr. Bora, you can't shortcut the process and come here to cover up all your defects which you've done before trial court.
So there also I had made the same submission.
And see, where's your application for condonation of delay? If you file an application substitution,
previous paragraph has my mention about my submission there. I had submitted.
See the operative part. Hence, with the above observation that is in application time part and no applicant will file a counsel the petition for condonation of delay. Then what the court prevented from considering even substitution or your restoration of your suit?
That was because substitution and restoration was clubbed together in the same.
Doesn't matter. Did you file for condonation or for consideration or put the reasons as to why the delay was caused?
The judge had,
which you put here very nicely in your application.
The judge had taken the applicability of Order 9, Rule 9, my lord. There also I had made submissions that Order 9, Rule 9 is not applicable.
You file an application Order 9, Rule 9.
That is why that was a mistake, as I said before.
So mistake, what mistake was made by whom?
Mistake by both parties. That both parties were under the belief that there was actually a dismissal of the case. When the dismissal order was against a
why have you come by 227 here? Why? What is so wrong with the order? They've come by 227 that it needs correction. You know, 227 part of the way limited. Why?
The dismissal
what has been done which has caused grave injustice?
Initially, both parties were under the impression that the dismissal order was a right order. That there was really a dismissal of the case.
Bora and counsel petitioner, Bruce impugned order dated so and so. Stop. The reason for dismissal of the application that trial court was substitution and the application of substitution and restoration was sued at trial court was due to the fact that no condonation application was filed together with the said application. Stop. Next paragraph. Case sought to be made out for the court to seek for this court to interfere in Article 227. No grounds have been made out. Furthermore, appeal is present under the relevant statute, matters then dismissed. Yeah.
Item number 3.
Where are we here?
In this case, the respondent number 1 and 2 are yet to file their affidavits in the contempt petition, my lord. What has happened is, when there was a policy for transfer, which was, my lord.
That seems as a doctor case.
Yes, my lord, the doctor case. Now, my lord, the Director General Assam Rifle is saying that it is the ministry which is trying to make some amendments, but the no affidavit from the ministry has come on record till date to show that there are actually some amendments being made, or there is some, or the policy has been kept in abeyance. Unless that comes on, my lord, there were earlier orders of the Honorable Court for their affidavit. That affidavit is not coming up.
Become a sole issue.
It is in fact, my
lord. There's no light at the end of the tunnel.
My lord, what has happened, my lord? We came out with a policy, my lord. Now there's
that policy has been, you backtrack that policy yourself.
My lord, there are several representations against that, my lord.
But then there has to be.
It can't be left like this. The doctors applied for transfer since.
But they were being sought to be transferred. Dehouse the policy.
Yes.
So now, what happens is, my lord, if the ministry comes up with a stand before this Honorable Court saying that we are not implementing the policy, we want to modify that policy, my lord, we don't have anything to say. It's a policy decision. But unless and until the ministry says something, would it be upon only the Director General of the Assam Rifles to say that no, we are not implementing it, do what you want? That is the whole situation. Either the ministry says we are doing it, or the ministry says we are implementing it. But it is not. Nothing is coming down from the ministry.
We have to do something, Mr. Dr. Mojika.
But I'll
Something
take it
the
up with
ministry
the
says, my
ministry.
lord, the next day, my lord, something comes
I'll
up.
take it up.
That is my only prayer.
Personally, my lord. I'll have instruction whether
It cannot be left at the.
if they want to change it,
the mercy, yes.
Because this was a policy which involved all the forces together. So it has to be a ministry level decision. Let them say we are changing it. We'll have our option of challenging it. Let them say we are implementing it. We abide by it. In fact, my lord, the last affidavit which was filed, where I had sought time to file a rejoinder, I went through it. It was the same thing which was filed earlier. The same affidavit has been filed. Same contentions. So I have not filed my rejoinder because it is the same contentions again. Nothing new has been added. No new stand of the ministry has come on record. Lordship gives them some time to file, to bring the stand of the ministry on record, my lord, the matter can be sorted out.
What happened to the other case? There's another matter regarding transfer.
That read appeal was disposed of on the last occasion. That submission was made. That time was given to the respondents to implement the whole thing. So that time expired in May. Therefore, Lordship had fixed it on June. Now in June also nothing has come up. Stands where it is. Therefore, my lord, either the ministry gives an affidavit saying,
I'll talk to them.
Either which ways, my lord. That is my prayer today. They cannot ignore the Honorable Court. I'm sorry to say that, my lord, but they cannot simply sit in ignorance of orders being passed here. Earlier, there were orders asking for the stand of the ministry. The Director General files an affidavit. That is the whole problem. Now, she may like to have a look at the order dated 24/2023. 24/2023. On request of so-and-so, who submits that the matter is still under consideration of the ministry, leaves the matter after 2 weeks, it is expected by the next date fixed, said affidavit should be on board. 20th of April 2023.
1 second. Yes.
That affidavit
you
never
just,
came.
yes. Take down. Mr. Aramazundar has drawn attention of the court to the repeated orders that have been passed, asking for an affidavit from the concerned ministry with regard to the current position as to the policy of transfer. So, this court noted concern the fact that the said affidavit nor the stated policy, you say, is yet to be put before the court. So, next paragraph. In this view of the matter, the learned DSEI is to ensure that an affidavit is to be before this court by
3 weeks time.
but feeling which a responsible officer should be present in court to answer from the Ministry of Home, correct? Yes, feeling which a concerned officer from the Ministry of Home Affairs be present in court to clarify the matter.
Yes,
up to 3 weeks. Why?
4 weeks.
It's about 4 weeks.
Final chance.
Yes.
Please.
Yes, answer.
4.
Much. 4 weeks.
Item 4.
Item 4 and 5, we have received the letter of These are matters relating to fifth pay commission again.
Mr. Yes. Yes. Contempt.
Well, these are the pay commission matters, my lord. We have preferred an SLP. SLP is likely to be listed in the month of July, my lord.
There is no stay till now.
Delay was condoned, my lord, and notice has been issued, my lord. When is the order also, my lord? The last
yes,
page
Dr. Mbose submits that the affidavit has since been filed. Stop. He further submits that it has been filed and that SLPs have been preferred against the orders that to be violated. He prays that the matter be taken after
4 weeks.
4 weeks, yes. Mr. Pathak, you want to file rejoinder? No.
No, my lord, not required.
5. Item 5.
5, my lord, same with 4 item. Item 4 and 5 are
6.
Your Lordship.
Yes, Mr. Paske.
Your Lordship, I appear for the petitioner herein wherein an implementment application has been filed.
Intervention application?
Implementment application, misapplication.
Where's the case? When was it filed? This case impleading whom, Mr. Paske?
We are pleading respondent number 4 and 5. Your Lordship. The Chief Engineer, National Highway, PWD Roads, Meghalaya, and the Regional Officer, MOD.
Yes, Mr. Shulai, you have any objection?
Lordship, so far the Chief Engineer, National Highway, Lordship, it's not required because he have already filed the affidavit on 9/6/2023.
And only regional officer?
Lordship, the remaining is only the regional officer, Ministry of Road Transport and...
Is that correct, Mr. Paske? Has the Chief Engineer already filed the affidavit?
Your Lordship, actually, the learned senior for the state only had made the submission on the 3rd of March 2023 that the said parties should be made necessary parties for proper adjudication of the matter. Hence, the Chief Engineer also was put in.
Is that correct, Mr. Shulai?
No, Your Lordship, what we made the submission is that the Ministry of Road Transport is very much a necessary party, Your Lordship, because the state is the only, because this is a central funded project.
Forget Ministry of Road Transport. Whether the Chief Engineer National Highway Division is necessary as a party?
No, Your Lordship.
Or roads will cover that also?
Lordship, that has already been substituted because Lordship kindly come to page 2 of the writ petitions.
Already impleted on 9/5/2023.
Yes, already implemented. That's
so now only one more, yes.
Only one more.
Yes,
that is the regional officer.
Then only respondent number 4, the MOD.
It'll be 5 now. Yes, Mr. F.P. Paske, Miss case number 143 in WPC number 444 for 2022. Mr. Paske, letter counsel petitioner. I've seen the application for implement of the Chief Engineer, National Highway, NH Public Works Department, Roads, Meghalaya, Shillong, and to the Regional Officer, Ministry of Road Transport and Highways, bracket MORTH, Government of India, Rajgarh Road, Guwahati, Assam, so. It appears this application has been filed seeking implementation of 2 additional respondents as 4 and 5. It is noted from the early orders that the Chief Engineer, National Highway, Public Works Department, Roads has already been implemented for number 4. Accordingly, by this application, this action will be limited only to the implement of the Regional Officer, Ministry of Road Transport and Highways also as per number 5. So obviously not objected to by Mr. N.D. Shurail and AAG. The said respondent registry to make the necessary correction to include the so-and-so as respondent number 5 stuff. Miss case stands disposed of. In the main case, in view of the order passed in Miss case so the so-and-so regional is implemented for number 5, petition to take step for service notice on the newly added respondent. Just after 3 weeks, yes.
Obliged, Your Lordship.
Yes.
Deeply obliged, Your Lordship.
Item 7.
Your Lordship, we have already filed our rejoinder and the pleadings are completed.
If parties submit pleadings are complete, it's a matter of hearing usual course and so on and so on. Yes.
Item 8.
Please, Lordship, in this matter, I have not received the authorised comments from the department, Lordship.
It's a last year's matter, Mr. Kharmi.
Yes, Lordship.
Your Lordship, in this matter, I appear to respond on number 3.
One second. How can you not receive? Who's the department concerned?
Revenue Department. The Deputy Commissioner has directed the additional Deputy Commissioner in charge of revenue.
Who's the additional Deputy Commissioner in charge of revenue?
From West Garowe. West Garowe.
The this matter has been filed since 30th of November 2022.
Southwest Garowe.
And it's reported by the learned additional senior government advocate that till date instructions are not forthcoming. Stop. Who are other respondents? Number 3. Mr. Paske for?
Respondent number 3.
Number 3.
That is the?
Private respondent.
Respondent. Have you filed affidavit?
Your Lordship, I seek some time to file my affidavit.
Yes. Next part is expected that by the next date, the affidavits of all the respondents should be on board, especially of respondent number 1 and 2, this up to 3 weeks.
Item number 9.
May it please, Your Lordship.
Yes.
We have just received, Your Lordship, the WS.
So we have filed a written statement on behalf of the returned candidate, respondent 1, as well as a miss case, my lord, misapplication under order 7, rule 11. We have taken the leave, my lord, on the last occasion.
Yes.
We have just received, Your Lordship. We seek some time to file the
objection to 711 application. Yes. Seen the application under this
order 7 rule 1. Your Lordship.
Yes, under 7 rule 11 filed by the your respondent number
1, my lord.
By the 1, and also the written statement. That's one number 1 stop. How much time do you require?
2 weeks, Your Lordship.
2 weeks time. Yes, 2 weeks time is next one. As per 2 weeks time is granted to the election petitioner to file objections to this application of 711. This is thereafter also.
Much obliged.
You give your name?
Yes, Your Lordship.
Item 10.
Your Lordship, they have wrongly calculated my gratuity, Lordship. My gratuity ought to have been, Lordship, 6,82,000, Lordship. 100.
My Lord, there is a contempt petition, and they have come before this honourable court on the pretext that we have not paid the interest, my Lord. We have calculated and we have paid, my Lord. This is the check. Now he is pointing out that the calculation is not correct. Then he has to file a different rate, my Lord. In a contempt proceeding,
we will close contempt because if it is
All right, Lordship.
Nothing remains for consideration at contempt application. The same is closed and disposed of.
Hello.
11,
Affidavit is yet to be filed, my lord. This is a contractual matter claiming for bills, non-payment of bills. My lord, we are dependent basically on the Union of India, my lord. So, I'm representing the Union of India, but I'm praying for some.
Yes,
4 weeks time.
as prayed, further 4 weeks time, can't respondents to file affidavit. Just the after on also.
12,
Lordship, I'm on behalf of Ms. P. Bhattacharjee.
On behalf of
Ms. P. Bhattacharjee.
where the petitioner, Mr. Jindal.
We have filed our affidavit and soft copy also.
Rejoinder, you need to file rejoinder?
Lordship,
You need to file rejoinder.
Lordship, we require some time for this matter.
Mr. Jindal, Learned Counsel for the petition, prays for and allowed 2 weeks time for rejoinder to affidavit filed by the respondents.
13,
Lordship, the interim order may kindly continue.
Interim order, if any, shall continue till the next date.
13,
We are yet to receive an affidavit in
I'm praying
opposition.
for some more time. We have taken sufficient time, my lord, but there's some typing of the lectures.
Yes, as prayed for the 2 weeks time granted response file affidavit.
Good year.
14,
Has number 5 retired and 8 died?
Yes, Lordship.
That's correct.
That's correct, Lordship.
So with the affidavit?
Lordship, I pray for further 2 weeks time to
16/6.
Lordship, I'm preparing respondent 6, 7, 9 and 10.
Yeah.
I received instruction, I will bring for 2 weeks time to file.
Yes, Mr. P.T. Sama submitted instructions has come to learn that respondent number 5 is retired and number 8 is expired. Accordingly, they should be struck off from the array of parties.
Lordship.
Okay, so Mr. Khan on behalf of respondents 1 to 4 and MS Wanyang on behalf of
6, 7, 9 and 10.
6, 7, 9, 10 pray for and allowed further 2 weeks time to file affidavit. Just thereafter and so on.
15,
I filed the affidavit. Lordship, I seek further time to find my rejoinder, Lordship, because
2 weeks for as prayed further 2 weeks time granted for rejoinder affidavit.
what's the rest, Lordship?
16,
Lordship,
Lordship, I filed my rejoinder affidavit in the matter, Lordship.
Lordship, let the matter be posted for hearing.
Parties submit the pleadings complete. It's a matter for hearing. We will vote on so and so. Any urgency? No.
Yeah.
I'll oblige, Lordship.
17,
Your Lordship, I pray for 3 weeks time to file.
Why do you keep on praying for time?
This is a second prayer, Your Lordship. I'm for respondent number 2.
What's the matter about? Contract?
No, Your Lordship, it's about payment of rent.
Okay. Yes, further 2 weeks time granted to. What about number 1? If I like it, no. MS MBSI on behalf of number 2, please for the Lord further 2 weeks time to file affidavit just thereafter and so on.
18,
Yes, Ms. Kourtney.
I appear for the state respondents here, my lord. My lord, I require further time. I'm waiting for instructions from the department.
What about number 6? Yes, so Mr. S. has entered appearance on behalf of the respondent number 6 today. So no further. So the service is complete. Stop. This is matter after 3 weeks for affidavits by the respondents.
Hello, Lordship.
19,
May it please your Lordship. Lordship, the matter is fixed for filing of affidavit by the respondents.
My Lord, I pray for some more time.
Just a humble prayer if the state could be directed to expedite a little bit in this matter. Reason being, the petitioner has been calling me and he's saying that he is not having any money at all and his family is suffering a lot due to the termination from service.
The legal aid matter? It's a legal
aid matter. Yes, my Lord.
Termination. 2 weeks further time granted to the respondent to file affidavit. As prayed for the 2 weeks time granted filing.
Oblige me.
20,
Just Lordship, I have taken a step to issue notice to the prohibition in 4 and 5, Lordship. Yet to be still awaiting.
Office note indicates that the service report not complete in respect to response 4 and 5.
But we are yet to receive instructions. May pray for 3 weeks.
Next paragraph is SN Leonard Senior J submits that he is yet to receive instructions on this matter after 3 weeks for affidavit for service report on respondents 4 and 5.
Lordship. Lordship.
second call, supplementary list, item number 2.
Yes. Yes, Dr. Mujika. You need to file affidavit this matter?
I need to file affidavit. This is a promotion matter.
Yes, Mr. M. Chanda, the counsel petitioner, issued notice. Dr. N. Mujika, together with assisted by so-and-so, Emerson Thal, is present, accept notice on behalf of all the respondents. This time after 3 weeks for instruction of affidavit. Yes.
Item number 3.
This matter?
This will go to Miller. AFT Miller.
It's mixed up. That's what this is going to say. It's mixed up with he's on deputation of rifles.
No.
Then he was recruited in the military unit.
My lord, so AFT is not functional. I have made a specific category statement, my lord.
Why?
My lord, it's not functional.
It's not functioning now?
No, my lord. Still yesterday I have checked, my lord. And at the time of even the affidavit, make the statement that AFT is not functional.
Where is the statement?
My lord, it's para. My lord, para 4, page 9, my lord.
Is not functioning? Is defunct or there's a vacancy in the? Mr. Chanda is Armed Forces Tribunal functioning body.
Now it is closed up to till 17th. 18th it is going to be reopened.
Then?
My lord, as of it's going to open, my lord. It's if then it will full-fledged functional, my lord. I will definitely ought
is
to
it functioning full.
No, full-fledged.
Then?
Full-fledged functioning, but now holiday, summer vacation.
There's
So
no
once
interim
the
relief
noti-
required even.
Huh?
Even
there's no urgent interim relief required. They can wait for 10 days.
You wait for 10 days. This is matter on the request of the Council of This matter on 18th of July in the motion column. Record करते हैं.
Hearing, item 21.
What I bought 22. Yes.
But as far as AFT is concerned, who was making a query,
Yes.
AFT might not, administrative member is there is no judicial member appointed.
Oh.
So there is no regular
Sitting.
21 minor, we have already filed our
Forgotten everything.
My lord.
Because of MSR data, it took so long. Yes, what is the matter about?
My lord, this is similar. This is the contempt matter. My lord,
Yes, similar to what I don't. The court doesn't remember anymore.
That's what, my lord. My lord, I have filed the written argument. My lord, Mr. Paul, he wants to submit before this court. So, my lord, we fix it on Monday, my lord.
What is? Mr. Bharat, you come. Yes. Though MSR Datta has filed an arguments today, she prays that she prays that her senior be heard. We listed after
next week, my lord.
My only prayer that the content may be closed by giving the liberty to file a president petition. They are asking for some subject.
heading for that anyway. Yes, no, let him submit. Listed after 2 weeks. Yes, so.
25.
My lord, in this matter, my lord, I had extensively argued on the last day. Today, I'd like to point out two orders, my lord. The first they say they have given me the appointment on the intervention.
Yes, Mr. Yobin.
Yes. They have given me the appointment on the intervention of the governing body, my lord. What did the governing body say? My lord, they said.
No, Mr. Yobin, see, you're on one point. How can we reconcile? Yes. How can we reconcile that period for which you stated to have been working? That's the only thing. You can show some way out. See, that relief can begin.
My lord,
we're stuck on that point.
Yes, my lord. For that, yes, my lord. For that matter, my lord. Now the respondents cannot say either you take it the first 6 months or you take it the last 6 months. But both you cannot hold it because they cannot say that because it is not my fault, my lord. It is their fault. It is their fault, my lord. The governing body said allowed to join, my lord. The governing body never said reappoint him or give him a fresh appointment.
When he coming back
the
to
governing
Shillong?
body said, my lord.
When he come back to Shillong?
I'm coming back Sunday. Sunday, my lord.
We're here in person. We finish it up next day. Only look for a way how to reconcile. It's only that reconciliation of that period.
My lord.
Correct.
My lord.
Either at the beginning 6 months, my lord, or the ending 6 months.
Yes, beginning 6 months and 6 months. How do you want to reconcile that? All right, some substance, everything else is
my lord. I'll try
under the bridge.
Yes.
Yes. Mr. P. Yobin prays that he may be here personally, physically on the next day. This is matter when you're in Shillong. Courts at the mercy of lawyers were traveling around, falling ill at
my lord, Friday, my lord. Next Friday, my lord.
Next
Friday, my lord. Next coming Friday, my lord.
Friday is a very bad day.
Next Friday.
Next Friday is 18th. No, what next Friday is? 14th. 14th. No, 14th.
14th.
There.
My lord. Either
Thursday
or Friday, my lord.
18th. 18 you'll be here?
18, my lord.
Yes. Please try to compete on that day. Yes.
My lord, 18th I should be there, my lord.
Yes.
29.
You're all brothers. You both be brothers. No.
This is the matter, my lord, the suspension was kept indefinite, and he was placed under suspension from 2017 till today. In earlier occasion, learned EAG was relying on the decision rendered by Madras High Court.
Yes? Who, Mr. Shulai? Only 3 courts we have, and still we are being incapacitated. If you adjourn all the matters in the beginning, for the hearing list, you decimate it by 90%. What do you expect this court to do then? And you see at the end of the board, but by the time we start, we already at the end of the board. Right.
31.
We'll do one thing. Tomorrow is Friday? No.
Friday.
See, the thing is that what is heard.
It was to some extent Lordship has heard the matter. Only the issue is, my Lord, the application of the Madras High Court judgment.
Then we listed on the 19th of the fixed matter.
Yes.
Yes, please tell. On the prayer of the MS Arkulni, matter stands. Matter is let the matter stand over to 19th 7/2023. Some matters we have to put closure. It's like that we can't just keep adjourning and. And if I start fixing matters as fixed items because I see that there's a tendency to adjourn, then I'd expect that that might have done that day. Because sometimes, now because you've made me lazy in the sense that I don't read the briefs anymore. Because if I look at a brief, also there's no point. I come, it's adjourned. So you made me lazy. When I go home, I don't open any file also.
We also recollect when we were junior, my Lord, the Guwahati High Court time, the courtesy shown among the lawyers, so they prepare and they do the case.
Yes,
we are missing those practices also.
So that's why you have a fixed matter. At least then you'll have. I can have assistance of the lawyers, and also the court can apply its mind. So sometimes
Senior counsel is actually ready to argue this matter today. It's just that.
Anyway.
Before his Lordship has pointed out about how to devise. Maybe
yes,
item number 1, 2, 3,
first
4.
5 matters.
Yes,
no adjournment.
That is also one good device.
31.
Yes.
Much appreciated.
Please, Lordship. Yes, this case, Lordship, we wanted to introduce one document, Lordship, which is very important.
No. What about talks of settlement? Last time, who's Mr. Kharmanda?
My colleague, Lordship.
Where's he?
She's in Chimba, Lordship.
Then she made a statement that settlement talks are going on. Is that correct?
Your Lordship, Ms. Zeti Nonkandri is handling this matter. She's on legs with assisting Mr. N.D. Shulai, Your Lordship. I was informed, Your Lordship, they were supposed to file an affidavit.
What affidavit? What about settlement talks?
I have no idea, Lordship.
Then it is from your chamber when you said settlement talks are going on?
But I don't know whether that settlement is there or not, but we were under...
This is matter next week in the order column. Monday.
Your Lordship, in the meantime, just pray that...
No, this is order column. We'll find out. Bring that, what's her name? MS Kharmanda. You can't tell the court settlement talks going on and another person comes and says want to file affidavit.
Okay.
There has to be some discipline in the manner you conduct your case also.
38.
Obliged, Lordship.
Yes.
I'm ready, Lordship. Mr. Debnath is.
Where's Mr. Debnath?
Regarding the recruitment process, Lordship, despite 5 to 6 years.
Yes.
It's regarding the recruitment process, they've called for the interview and I've participated. Now almost 5 to 6 years there. The results have not been declared yet. We just want a declaration of the results. That is our limited prayer, Lordship.
Exams are held when? Interviews correct in 2015.
Lordship. Now they have even sent the name of the successful candidate for approval in the year 2015. Now they're still sitting over there.
Have you filed affidavit?
I filed it.
What do you see in the affidavit?
Affidavit you receive saying that there was Ben and then after that it was not considered.
There was what?
And then after this
there was what was there?
Then after this you receive this.
No, what was there? He said I couldn't catch it. There was
ban you receive.
Ban on recruitment. Where's that? Where we said that? Where?
Should be page 4, Your Lordship. Page 4, para F.
Yeah. F is opening of ban.
Then para H also, Your Lordship, page 5.
In this case, what's happened? You receive subsequently after that. when this petitioner was make the advertisement, this respondent hearing, at that point of time, it was the locally there is pre-appointment, and subsequently it was centrally to be sponsored.
Then why did you go through the recruitment process then?
So subsequently centrally processed recruitment and the petitioner participated, then he was not successful. And he is saying that
he's not successful.
He was not subsequently when the sponsor it is sponsored by centrally. Earlier it was
where have you said that in the affidavit? Show me the relevant parts where you said that first it was a ban, then the ban was lifted, then what kind of recruitment was done, then other memorandums or notifications that came out that the should not be done locally. Show that.
Can I have another detail?
What we can have another date?
Today actually I didn't go to body.
You're not prepared. This court is tired of this now.
We are not seeking any appointment. We just want the declaration of results.
See, there are certain points now which you have to clarify. Was there a ban? It was a ban. Why the recruitment process continued? Number two, was there a limitation to recruitment? Was there any that locally should be recruited? Number three, that or locally should not be recruited? What happened? Why did it fizzle out? What happened? This whole writ is based on legitimate expectation.
It's true.
You should know what happened. We'll have it after 3 days. We'll have it for 1 week. You come up with instructions. Mr. Adel in the course of bringing 3 days, he will have to obtain instruction which has been expressed by the court with regard to ban on recruitment or whether there was any ban on recruitment of local candidates. Stop that thing, yes. This is a matter of the 1 week. It's only 11, it's 12:30.